Hey, good afternoon, everybody. Pleasure to have you with us. I'm Rick Hess, Director of Education Policy Studies at the American Enterprise Institute. Today, we're here for a conversation about the future of college admissions, a conversation with Edward J. Blum. We'll talk specifically about college admissions, but obviously in light of so many changes going on with President Trump's executive orders, and with what's happening in terms of DEI and civil rights enforcement, I think our conversation is going to touch on much that's happening in higher education beyond specifically college admissions. Let me first say a couple words of introduction for Edward. Edward J. Blum is the president of Students for Fair Admissions, launched in 2014 with the goal of eliminating racial and ethnic classifications in school admissions. SFFA may be best known for its landmark fight to challenge race-based preferences at Harvard University and the University of North Carolina at Chapel Hill. In 2023, of course, the United States Supreme Court struck down race-based preferences in student admissions in Students for Fair Admissions versus Harvard. Edward is also president of both the American Alliance for Equal Rights and the Project for Fair Representation. A visiting fellow at AEI, he's the author of Unintended Consequences of Section 5 of the Voting Rights Act, numerous essays and law review articles, and he's a frequent contributor to the Wall Street Journal, USA Today, LA Times, Washington Post, and National Review. Here's what's going to happen today. First, I want to talk a little bit with Edward about how Student for Fair Admissions got started and how it came to play the role it played. Then we want to talk a little bit about the litigation that led to the Supreme Court ruling 2 years ago. And then I particularly want to start talk about some of the implications and impacts on what we're seeing more broadly in higher education today, both under President Trump's executive orders and when we think about DEI and the rest. And at some point in there, we will open up the conversation for questions from viewers or the audience with us in the room. Those of you watching at home, you can share questions by emailing Anna Lowe at anna.low@aei.org or sharing questions on X under the hashtag AEISFFA. That's hashtag AEISFFA. Edward, let's start at the beginning. How did you come to this work, and how did you come to found Student for Fair Admissions back in 2014?
Well, I think there's two parts to that question, and let me just briefly tell you how I became involved in the issue of race and ethnicity. I was on Wall Street from 1979 until 2000. And I then came to Washington, D.C. and affiliated with AEI. But in 1992, I found myself as the Republican nominee running to represent the 18th Congressional District of Texas. It was a Houston area congressional district that in 1990 had not fielded a Republican candidate. And the fact that 600,000 people go to vote in a congressional election and there's only one candidate on the ballot, that distressed me. And 2 years later, I am now the Republican nominee. It was a district in which about half of the population was African American and the other half divided about equally between Hispanic and white. In the course of campaigning, going door to door. That's what candidates did back in the early 90s. People would actually answer their door when there was a knock or a doorbell ring. We'd pass out literature, my wife and I and volunteers, and I noticed time after time, street after street, neighborhood after neighborhood, African American families who lived on one side of the street were drawn into the 18th Congressional District. And Hispanic and white families on the other side of the street, or a block north, were drawn into a different congressional district, a white congressional district or a Hispanic congressional district. And this just didn't happen once or twice. This happened throughout the city of Houston, block by block, neighborhood by neighborhood, multiracial, multi-ethnic neighborhoods were split apart to create these racially homogeneous voting districts. That also bothered me, and in 1993 I filed my very first lawsuit challenging the constitutionality of the racial gerrymander that existed after redistricting in 1990. My very first lawsuit made it to the US Supreme Court. And in that opinion written by Justice Sandra Day O'Connor, she found, joined by 4 of her colleagues, that the district was a racial gerrymander, and it fell outside of the constitutional provisions that, and also the Civil Rights Act. And she compelled the case to be sent back to the state of Texas, and those districts were then redrawn. That was a very gratifying experience for the first time in court. So that's how I became involved in the issue of race and ethnicity in our public policies. Now, let me talk a little bit about students for fair admissions, because that's why you're here. I don't want to take you into the bones in the ground like a Michener novel, but the story really begins, SFFA's story really begins in 1992, the year I ran for Congress. The year I ran for Congress was the year that a young woman, also in the state of Texas, named Cheryl Hopwood, sued the University of Texas, arguing that the use of race at UT Law was unconstitutional. She had been rejected from UT Law. UT Law admitted that they used race and ethnicity as a factor. Her case went before a district judge. She lost. Then her case was appealed to the Fifth Circuit Court of Appeals, where she won. That opinion, written by Judge Jerry Smith, said that the use of race in college admissions is really not a compelling governmental interest, that the hurdles that the University of Texas needed to overcome were not met, and the use of race is now no longer permitted. The University of Texas appealed that opinion to the United States Supreme Court, and the Supreme Court did not take that case. So now you've got the state of Texas, the state of Louisiana, and the state of Mississippi that has forbidden the use of race, just those 3 states, where the rest of the country, the 47 others, permit it. All right, now that's a very interesting outcome. This is 1996. George W. Bush and the Texas legislature, in response to that ruling, because that ruling then precipitated a dramatic fall off in African American and Hispanic admissions to Texas and Louisiana and Mississippi's most competitive universities, the state of Texas passed something called the Top 10% Plan. And the Top 10% Plan was, I see my friend Rick Kahlenberg here, the Top 10% Plan basically allowed any high school graduate who graduated in the top 10% of his or her high school to be automatically admitted to any public college or university in the state of Texas. Regardless of SATs, regardless of anything else, you're in the top 10%, you get to go. All right, what happened to the drop-off in minority enrollment when that policy, when that statute went into effect? It skyrocketed. African American and Hispanic enrollment at Texas' most competitive universities exceeded what was accomplished by race-based affirmative action. So now we have a race-neutral policy that applied all over the state of Texas. A lot of kids who went to rural high schools in West Texas, now they are much more in attendance at UT and A&M and what have you. Okay, so now we've got Cheryl Hopwood, Fifth Circuit opinion, top 10% plan. Stay with me on this, ladies and gentlemen. I'm gonna take us there pretty soon. Now we have a young woman named Barbara Grutter. Ring a bell? Grutter versus Bollinger. Barbara Grutter applied to the University of Michigan School of Law and was rejected. Her case went through the district court, the Court of Appeals, and then finally up to the US Supreme Court, where something kind of remarkable happened, and that was Sandra Day O'Connor wrote an opinion that said the use of race as a college admissions factor, at least for 25 years going forward, is a compelling governmental interest, that the pursuit of diversity does fit within our constitutional framework and our civil rights laws. So, all right, now we've got the Supreme Court saying this is okay, but now we've got the University of Texas, the president of the University of Texas, 2 hours after that opinion came out, issued a press release stating that the University of Texas was going to reintroduce race and ethnicity as a factor in college admission at UT. So, but if he had read the opinion specifically stated that before a college or university uses race as an admissions factor, they must attempt to use a race-neutral factor, a race-neutral program to achieve the diversity that they seek. Well, wait a minute, Rick. We've got the University of Texas using a race-neutral factor that has actually exceeded the use of race and ethnicity, but now UT is going to reintroduce race on top of this race-neutral statute. Okay, when I read that, I'm getting to the point here. When I read that...
Hey, we've got people in the audience who weren't even born when some of this went down.
Yeah, I'm afraid that's right. When I read that, it was like, wait a minute, this is actionable. I need to find someone who was rejected from the University of Texas to revisit what the University of Texas has just announced it's going to do. So between 2003 and 2008, I made phone calls, I called friends, I gave talks, I did everything I could until I found another young woman in 2008 whose name is Abigail Fisher. Abigail Fisher, I can see some heads nodding yes, they recognize the name. Abigail Fisher applied to the University of Texas in 2008, and even though she was in the 11th percentile of her high school class, she was rejected. So I convinced the Fisher family, who I had known for quite some time, to file a lawsuit challenging the University of Texas's reintroduction of race in their admissions policy. That lawsuit, Fisher versus the University of Texas, never challenged the use of race in general. We never said, let's overturn Grutter. We never did that. We just said the reintroduction was out of bounds. Abby's case, district court, where we lost, Fifth Circuit, where we lost, went to the Supreme Court, and guess what? In I think it was a 7-1 opinion. I think somebody was recused. The Supreme Court, with an opinion authored by Justice Kennedy, said, the courts that looked at this below, the Fifth Circuit that looked at this below, applied a standard of review that was just too low. In order for you to kind of jump over the use of race and ethnicity, the bar needs to be up here. And the Fifth Circuit lowered the bar down here, and we're going to send this case back, and they're going to have to raise the bar to see now if this higher threshold is warranted. if they are allowed to reintroduce race with this newer threshold. That was the beginning of Students for Fair Admissions, because that new threshold convinced me, and convinced, more importantly, convinced a lot of very smart lawyers that I have known over the years, that this is now, with this new threshold, this is now actionable in court. And what we ought to do is sue a very prestigious private university, the oldest in the country, Harvard, and we ought to sue a very prestigious public university, the oldest in the country, the University of North Carolina. So the opinion came out, Abby's opinion came out in 2013. A year later, I formed Students for Fair Admissions, a membership organization. A rejectee from Harvard joined, a rejectee, a young man from North Carolina joined. We had about 30, 40 members at the time, and we went into federal court in Boston and in North Carolina, and we sued. That's how this came about. Now, there's a postscript that makes this a little more dramatic than it already is. Now, Abby's case, we're back to Abigail Fisher. Abby had her case remanded back, remember? Now we've got her case coming back to the Supreme Court once again, because Abby lost at the Fifth Circuit when her case went back. Fifth Circuit said, okay, we're going to raise this hurdle, but we're looking at the facts, and we think that the University of Texas has overcome that hurdle. So Abby's case goes back to the Supreme Court in 2016, and in a 4-3 opinion, because Justice Scalia had passed away, I think Justice Kagan was recused, we had a 7-member court, Abigail Fisher lost her case. And the court ruled that the use of race at the University of Texas passed constitutional scrutiny. Okay, that's 2016. Back up 2 years, now we're in the Harvard litigation. So you just carry on. We made we had a trial in the Harvard case in 2018. We had a trial.
So let me ask you to pause and back up a bit there.
Go ahead.
Because Edward, I think one of the things that is on people's minds right now is under, say, the president's executive order around, what it means to comply with Title VI on campus and around DEI. Is I think people expect a lot of investigation and oversight and litigation. So I'd be real interested. I mean, for me, one of the fascinating windows opened up by your litigation with Harvard and UNC was the deposition stuff that came out. What surfaced? Can you talk a little bit about how you settled on a strategy, how the depositions got taken, how this stuff came into the public consciousness?
Yes. Fortunately, one of our expert witnesses in the case, Rick Kahlenberg, is here with us.
He's always headed in for Harvard Law.
Yeah. Well, part of it is when you go into litigation like this, where discovery, where we're deposing Harvard's experts, and we're deposing Harvard's admissions officers, and they're deposing our students, they're deposing the SFFA leadership, you sometimes just don't know what's going to happen. The documents that Harvard, more so than UNC, the documents, the emails, the data that Harvard had to disclose to us, that we then analyzed, our quantitative expert, Peter Arcidiacono, an economist from Duke, went and analyzed granularly, the racial differences in quantifiable metrics between African Americans, Hispanics, whites, and Asians. That was revelatory. That had never, ever been quantified for the American public before. And it was a front page New York Times story when that data was released into the court record. The depositions told us a great deal also about a scandalous part of this case, and that was the personality scores that the Harvard admissions officers assigned to Asian kids, white kids, Hispanic kids, and African American kids. And that was a front page story in the New York Times and elsewhere. As we all know now, the personality scores for Asians were abysmal. The scores that they received, the quantifiable scores that they received, indicated that the majority of Asian applicants didn't have leadership qualities. They weren't likable. They were
It's
too
tough to quantify
serious.
likability anyway.
Whereas the other racial groups far exceeded them, of course. So that was something that also came out, that if they're doing this at Harvard, then perhaps it follows that they're doing this at Yale and Princeton and Duke and Stanford and elsewhere. So,
And I mean, also you guys had these troves of emails, which just, I think, raised lots of eyebrows when people started to see how the admission staff were talking about students, about some of the back and forth with university leadership.
yeah, that was another very, I think, embarrassing aspect for Harvard specifically. Their discussion of individual students, the give and take between administrators, the memorandum of the studies. It was now. Some of this is. I'm now recalling this for the first time since 2018, 2019. Harvard did a study, even before we sued them, in which the question posed to Harvard's internal research department was, are we discriminating against Asians? This was the question. Are we discriminating against Asians? And the internal research department at Harvard came back and said, yeah, you are. Yeah, you are. And of course that came out during discovery. So this is just the nature of litigation, that the discovery process was 3-ish years or so. When Abby's case came back to the Supreme Court in 2016, everything was put on hold. The lower courts put everything on hold to see what the Supreme Court was going to do in Abby's case. So from beginning to end, it took about 8.5 years. There's an old saying within the kind of the rabbinical community, the impossible takes longer, and that's what it was. That's what this lawsuit was all about. It was trying to do the impossible.
Now, one part of this obviously is that the court found that race-based decision violated the 14th, but it had the carve out particularly for the military academies, which is a live question at right this moment. Can you explain a bit about what was going on there and how we should understand the significance?
Yeah. Footnote number 4 in the Harvard opinion wasn't really a carve out, Rick. I'm going to call it a statement of agnosticism. The court said that perhaps. They didn't use the word perhaps. It would have been wonderful if they did, but perhaps the military academies have some unique aspect to their training, their needs, and because the United States wasn't a party to this litigation, then we're going to keep our hands off of it. So what did SFFA do? of course, this is like a trout going up to a worm on. So a few months later, SFFA sued the United States Naval Academy. A few months after that, we sued the United States Military Academy at West Point. And just a few weeks ago, we, SFFA, sued the United States Air Force Academy. All three of those academies, of course, are under the umbrella of the Department of Defense. So we went to trial in our case against Annapolis a few months ago. We lost at the district court, and that case is now on appeal to the Fourth Circuit. The West Point case may go to trial sometime this fall, and we don't know yet about the Air Force case because it's so new. But those are coming up.
Now, the other complexity, one of the other complexities in the ruling was Chief Justice Roberts drew a distinction between race-based admissions and the ability of colleges to consider questions of how students had student experiences and how they'd engaged with issues around race-based questions, for instance. Can you explain kind of why that's significant and how that's played into kind of implementation of the court's decision?
Well, I wish I could. The implementation of the court's decision is mystery right now. We don't really know what Duke, Emory, Northwestern, Stanford. We don't really know how they have incorporated that aspect of the court's opinion. We don't know how they have incorporated the use of essays in the court's opinion. So there's just still a lot of unknowns.
And why
right
is
now.
that? Why don't we know?
Well, private colleges and universities are under no FOIA requirement to explain what they're doing. Now, the University of Louisiana, LSU, the University of Florida could get a FOIA request and say, tell us exactly what you're doing in detail. A legislative body, the state of Florida's legislature could call up the leadership of any university and say, bring your admissions people up here because we want to know. You can't do that at Princeton. You can't do that at Rice. It is possible, and I think many are hopeful that question and what's going on will be explored by the Department of Education, the new leadership of the Department of Education, and perhaps the new leadership at the Department of Justice.
So just to make sure I understand what you're saying, so we don't really have good visibility into private colleges, universities, if they're abiding by the court's decision.
Well, yes, and here's why it's a little befuddling. So, of course, when the Harvard case was at the U.S. Supreme Court, Harvard's amici, those organizations, colleges, corporations, policy institutes that favored what Harvard was doing, wrote amicus briefs in support of Harvard. One of those amicus briefs was authored by some of America's most competitive private colleges, including Yale, including Princeton, including Duke, and some others. In that amicus brief, those colleges, and I think there were maybe 20 of them or so, 15 or 20, they wrote that without using racial classifications and racial preferences, the diversity at our schools will plummet. That statement was before the court. Now, here it is, a year after the SFFA opinion came out, and what has happened at three of those schools, Princeton, Yale, and Duke, showed absolutely no significant decline in racial diversity. None whatsoever. And in fact, there's a handful of schools that actually showed greater African American enrollment, and a significant drop-off, by the way, in Asian enrollment. But let's go back to those three: Princeton, Yale, and Duke. So either Princeton, Yale, and Duke misrepresented that to the Supreme Court, or they're using some kind of a racial proxy, and we don't know what they're using, what racial proxies they may or may not be using, to maintain their racial diversity. So perhaps the leadership at DOE might want to explore that. There very well may be a lawsuit that's brought against one of those colleges or universities, or multiples. We'll just have to wait and see.
And now the public institutions that you've referenced, obviously there's the opportunity for FOIA, for legislative oversight. How much of that have we seen? Do we know more about what they've actually done or not done as far as respecting the court's decision?
Not yet, but that is underway. I can speak from some experience that there are a number of organizations, policy institutes, public interest legal organizations that have FOIA'd a number of our most competitive public universities. Those FOIA requests, if you've ever done one, a complex one like the one I've just described, it can take months and months. And so we'll just have to wait and see.
And have there been any particular legislatures that have stepped up on this, or could they be doing a lot better in terms of oversight?
Well, I think, I wish I had a knowledgeable reply to that. I think the state of Texas and the state of Florida have required the leadership of those elite universities in those states to disband what is now known as DEI. But as importantly, I think they are probing what is going on in the admissions offices at those flagship universities. I don't have knowledge of what they've uncovered, but I think with time we're going to learn a lot more.
So I want to turn to kind of what's going on today more specifically. But first, let me hit pause. I know that you've often been attacked. You've had, epithets thrown at you that you are a mean person for obviously doing this work, a racist or a bigot. So I'm curious, how do you answer those responses? And how do you feel about the importance of racial diversity on college campuses?
Okay, well, there isn't really enough time in my day to answer hateful email and Twitter remarks and cell phone messages, so I just don't do it anymore. Every now and then, someone will write me an email that is very thoughtful and inquisitive, wanting to know, why are you doing this? Because I think it's now in the Wikipedia. Most of it's wrong, but the part that Wikipedia is right is I grew up in a liberal Jewish household, a working class Jewish household. My mother and father spoke Yiddish, the language of Eastern European Jews. It's true, I am the first Republican my mother ever met. And so every now and then I'll get an inquiry about, you're Jewish, you grew up in a liberal household, what's with you now? And what was the second part of your question?
How do you feel about the importance of racial diversity?
So racial diversity. The question implies that someone's skin color is going to tell me something, very fundamental about who they are as an individual. Now, I don't believe that's the case. I have met dozens and dozens of Asian American kids over the last 10 years, and they're all unique, they're different. Some are outgoing and some are shy and some are studious and some just care about sports. Your skin color, the shape of your eyes, The texture of your hair tells me nothing about who you are. For some people, being on a campus with racial diversity is important. They want to go to a school in which they're going to interact with people who look different from them. Now, that's fine. There are others, and I've got a really interesting example. There are others who couldn't care less about that. And my example is Spelman College. Spelman is one of the, I forgot how many historic black and black colleges and universities in the country. It's in Atlanta. It is an all-women's college, and it is all black, period. All women, and I think 99% black. They have, I think, somebody can Google this while I'm talking, I think they have something like 20,000 applicants a year applying, and I think the admissions rate is around 30-ish%. So here you've got African-American young women, academically talented, want to attend a college where there are no men, there are no whites, there are probably no Jews, no Hindus, no Asians, no Hispanic. What are they attending a college in which their experience will be diminished somehow because they don't know an Asian or a Hispanic? I think if you ask those women, their answer would be no. I want to go here, and I'm glad I was accepted, and I'm delighted that I graduated from here.
So when it comes to the court saying potentially for the U.S. military academies because of leadership preparation, it's important. Is your answer the same in that context as well?
Absolutely. I think we presented a very compelling case to the lower court in Annapolis, and during that trial, one of Annapolis's experts, a Navy admiral, a retired Navy admiral, was asked the following question. Okay, you're saying that racial diversity is really a necessary factor for the lethality and the cohesion of the Navy's fighting force. So tell me how race plays a factor in all of that in a submarine patrolling the waters off of Taiwan. Tell me how, different skin colors are going to add to the lethality of that nuclear submarine. And there was a long pause, and it was almost embarrassing. There was no good answer to that. So I stand by what we presented in court, that lethality doesn't require your shipmate to look different from you.
So, over the last couple of weeks, I think there's been a lot going on in this town, obviously. The new administration has issued a raft of executive orders. The ones that directly affect, one of the executive orders directly affecting colleges and K-12 schools dealt directly with diversity, equity, and inclusion, and made specific reference to the SFFA ruling in terms of the court's interpretation of the 14th Amendment and what constitutes permissible and impermissible behavior. Curious is perhaps the person who was thought longest and hardest about the path to that court ruling and what to make of that court ruling. Can you help us understand how that translates into this DEI conversation? And when colleges are thinking not just about admissions, but perhaps about DEI activities more broadly and about campus culture more broadly, are there insights or takeaways that you would bring to our attention?
Wow. I think the world of DEI in higher education some of the policies that have been in place really since the 2013, 14, 15, and then especially put in place after the George Floyd killing, those policies and programs were illegal even prior to the SFFA opinion. The SFFA opinion, I think, energized some aspects of the public interest legal world, energized legislative bodies, and now has energized this administration to really stop these policies that have really never been legal. So
can so that's obviously a strong statement. I'm sure folks are wondering, so what are some of these illegal activities that have been going on?
All right. So I'm going to take off my SFFA cap for just 1 second and put on another cap. In 2021, I formed another membership organization called the American Alliance for Equal Rights. This is kind of a sister organization of SFFA, except the American Alliance for Equal Rights has a broad litigation portfolio. SFFA was only college admissions. The new organization looks at employment, looks at contracting, looks at other areas of our public policies. Since the SFFA opinion came out, and I'm not trying to dodge your question, but I think this might even be more interesting. We have filed, I think, 15 or 16 different lawsuits challenging corporate racial preference programs, law firm racial preference programs. And the argument that we've made in court has been when McDonald's, because we sued McDonald's about 3 weeks ago, when McDonald's established a scholarship program 3 decades ago that was open only to Hispanics. No African Americans could apply for this. Something like $30 million has been given away by McDonald's over these decades. We challenged that, and McDonald's folded within 2 weeks. And McDonald's recognized, and Perkins Coie Law Firm, who we sued, Morrison Forrester, who we sued, the Smithsonian, who we sued, Southwest Airlines, they've all recognized that these policies involving fellowships, internships, hiring, promoting, all of these race-based policies and programs were illegal even prior to the SFFA opinion. That Title VII forbid it, other aspects of our civil rights laws forbid it. So that, I think, is the next wave. That wave will continue. It started with SFFA, that energized the public interest legal community, it energized state legislatures, and now we're going to see that ripple through corporate America, cultural institutions, and others as this goes forward.
So let me ask one question, then I want to open it up to everybody else. So one thing that this has me thinking about is that public interest litigation seems like it can either cause some of these firms to fold on the issue in question, or you can, log 8.5 years and wind up with a. But it also sounds like, especially with a lot of these nonprofit institutions that may not have as sharp a bottom line concern, we don't know if they're abiding by the Supreme Court's decision. So as I can imagine that we will be a theme that we will return to in some of this DEI work, that colleges may say that we have changed or may rename things, but the question of figuring out whether or not they're abiding by statute and constitutional law, will that be more difficult for public interest law firms to kind of ensure? Like, how do we think about that next step once there's been a courtroom victory?
Yeah. litigation like the SFFA cases, and even the Grutter and Fisher cases are enormously time-consuming. They're expensive, and they're complex. And fortunately, it's just not SFFA that is involved in these endeavors. The Pacific Legal Foundation, Southeast Legal Foundation, the Wisconsin Institute for Law and Liberty. All of these organizations are relatively small compared to our friends on the other side. Their public interest legal organizations have massive resources and massive numbers of in-house employees, but we just carry on. And when a Target, just a few days ago, you may have read this, America First Legal, a fairly well-known organization, sued the University of California. That was just a couple of days ago, arguing that the UC systems, specific campuses, are violating the law. How long that case will take? Could take 8 years. It could take 2 years. We just don't know, Rick.
So when your friends at the Department of Education or the Department of Justice call you and say, Edward, how concerned should we be about these campuses just digging in and figuring they got 4 years to wait us out? How big a concern should that be?
Well, first of all, I would love that phone call. I would be on a plane from Florida up here to meet with whomever. This is an ongoing battle. All really cultural issues in law are there's no end point. I said that the Harvard opinion was the end of the beginning, not the beginning of the end. Of course, it's a famous Winston Churchill line that I plagiarized, but and it's true, whether it is race and ethnicity in our public policies, whether you are a libertarian when it comes to environmental issues, or you're much more of a kind of a greenie when it comes to environmental issues. Reproductive rights, that will be an ongoing battle in American cultural discussions and statutes and programs. So this is just the nature of this is like Hyman Roth in The Godfather 2. Many of you remember Hyman Roth in The Godfather 2. He said, this is the business we've chosen. So that's what we.
You hardly ever get Godfather references at think tanks. That's awesome.
Yeah, you've got to do that.
All right, let's go ahead and open it up. Let's start right here. Where's Mike? Greg?
Thank you, Mr. Blum,
And let me just do my usual reminder. Please tell us who you are, where you're from, and please ask a question. If we get 20 seconds in and I can't spot a question, we'll give someone else a shot.
Renu Mukherjee. I'm a fellow at the Manhattan Institute and also a PhD candidate in political science. Thank you, Mr. Blum, for your time and for all the great work you've done on this issue and others. I just wanted to ask a quick follow-up to your lawsuits against the service academies. While I find both professionally and as a military spouse, SFFA's arguments against racial preferences at the Naval Academy, West Point, etc., compelling and the correct route legally, I have concerns based on the arguments from the other side that whereas the educational benefits of diversity was the compelling interest advance in just regular colleges and universities, the service academies and the Biden administration played this as diversity being a national security concern. I was wondering if you could speak a little on, do you think that some of the justices that ruled in favor of SFFA, Chief Justice Roberts, Justice Kavanaugh, might want to invoke judicial deference if they're presented with the argument that, this is a national security concern?
I read your work, by the way, at the Manhattan Institute. It's always a possibility. You have to ask yourself in public interest litigation, what is the Hippocratic oath in filing a lawsuit? the Hippocratic Oath in public interest law is do no harm. So if a lawsuit is contemplated that could actually make the law and the policy worse than it is now, then don't file it. The SFFA and our legal team and others believe that if this does go to the Supreme Court, we have an excellent shot at pulling together the same kind of energy that we had with the Harvard case. I can also tell you that there was an executive order out of Secretary Hegseth in which the military academy's use of race is now perhaps going to come to an end by order of DOD and DOJ.
Right here. Right up front. Yeah.
Thanks. Mark Nadell. I was curious, the Supreme Court ruled against racial preferences because on the diversity issue. And I assume that the elite colleges introduced this whole racial preferences in the 60s because they felt they had done harm themselves and society had done harm to blacks in particular, and they wanted to do something. I agree with you that using racial preferences in admissions is not the way to do it. And also what you said with special scholarships, that also violates the law. My question for you is there another way that elite schools who feel an obligation to public service and to compensate, the compensation was not the way the Supreme Court went, but that you think they could do to serve the ends that they're trying to reach?
Great question, and you're right. You can't remedy past discrimination with new discrimination. But my friend, Mr. Collenberg over here, has spent his professional career writing books and articles about casting a net in directions that will harvest kids who have come from, lower socioeconomic backgrounds. Cast a net for kids who may be the first ones in their family to attend college, whose family income is, very modest, who have grown up in a single-parent household. That will cast a net like the top 10% plan. It's going to reach out to every racial and ethnic group and really create a uniqueness on a campus like Harvard, or a uniqueness like a campus like Stanford.
That policy sounds good, but it doesn't address the particular harm that was done to blacks that universities wanted to address, Lyndon Johnson wanted to address. Is there any way that you have thought of that would address that particular one?
No, I think I gave you my best answer, and that is, you can't remedy discrimination that took place in the 30s, 40s, 50s, and 60s by discriminating against Asians today. It cannot be done.
Right here, sir. Yeah, you had your hand up, right?
I did have my hand up.
Okay.
Yeah, thank you. Devin Westhill, Center for Equal Opportunity. It may sound weird, but I think sort of the legal fight around this type of thing is the easy part. What's harder is to change hearts and minds of society. I'd like to get your assessment of sort of the general milieu of societal thoughts and feelings about these issues, and whether or not that's different from when you started working on these issues and now. I feel like today we're in a different place. There's a real opportunity to persuade the American people that your view is right, and the view that they've been told was right for quite some time that pushes racial preferences or ethnic preferences is wrong.
Devin lives in Jacksonville. I live in Tallahassee, so we're just I-10, about 2.5 hours apart from one another. So I'm going to take issue with with just part of your statement. I don't believe that racial preferences have been popular ever. Let me talk about the SFFA opinion. So SFFA opinion comes out June 29th, 2023. Within 3 days, 4 days, Pew Research, the New York Times, the Washington Post, dozens of, well, not dozens, that many other polling organizations went to the field and said, race is now no longer permitted in college admissions. Do you agree or do you disagree? And nearly 70% of respondents to those polls, nearly 70%, including significant majorities of African Americans, said, yeah, I agree with this. If you look at polling going back, when CEO was formed, should race be an element in college admissions? The vast majority of Americans said no in polling. And we even have, Devin, we even have a better laboratory than just a poll. We've got statewide initiatives. Ward Connerly in 1996 brought a statewide initiative to the voters of California. The voters of California in Prop 209 had an opportunity to vote on the following question, the following proposition. The state of California will not discriminate against or grant preferential treatment to any individual based upon their race, their ethnicity, their sex, et cetera, et cetera. What happened in 1996? That passed. I think it was about 54 to 46 Californians. This is not Oklahoma we're talking about. This is California said we don't want race preferences in our public policies. Now, take that same vote in 1996 and fast forward it to 2020. The legislature got that question back on the state ballot in California. Should we reintroduce, these compensatory preferences and et cetera, et cetera? So should we reintroduce affirmative action in the state of California? By a wider margin, voters in California said no. They voted for Joe Biden. They gave Biden like 60 some odd % of the vote. Then, yeah, I'm voting for Joe Biden and all the other progressives on this ballot. But over here on affirmative action, no, I'm not voting for that. That signals, I think, America's dislike of all of this. So the DEI battle, it's been hard, but I think it's really now, in terms of the law, it's going to be a lot easier. And I think corporations, especially, if we're going to have a laboratory, see how quickly corporations have moved away from this. They do not want to be affiliated with the use of race and ethnicity in their corporate lives.
Rick, last question. Oh, Mike, please.
Great, thanks. Thank you for talking about the race-neutral alternatives. That takes away some of the sting of those who would accuse you of being cold-hearted. You said you're in favor of the socioeconomic preferences and the 10% plan. Of course, there are some that are further to the right who are now challenging those very plans. And I'm wondering what you think will happen if the Supreme Court takes one of those cases.
Rick, it's hard to say. There are, I think, race-neutral admissions factors that will pass constitutional muster. Then I think there are some race-neutral policies that are really not race-neutral.
For instance?
There are some tools that are being used that geographically map a student's census block. And it's much like redistricting. That data might be used as a proxy for race. So even though candidate A, B, or C, candidate A is now before the admissions committee here at Yale, What do we know about candidate A? Well, candidate A lives in a neighborhood in which there's high crime, there's very little home ownership, there's a lot of low income, so it's possible that that kind of geographic data might fall outside of a legitimate race-neutral alternative. It's a work in progress, Rick. So, but that's an example of something that may be a bridge too far.
Well, Edward, thank you for, I think, a terrific scan of the landscape of both how we got here and what's going on. I hope everybody who's been watching or with us today walks away with as many questions and as much to think about as I do. Appreciate your work and appreciate you taking the time today.
I'm delighted to have done this. Thank you.
Thanks so much. Bye.
Thank you.